As I have previously mentioned, procedural or adjunctive or adjective statutes are all referring to the same thing, that is, procedural laws. Modern jurists prefer to use the term procedural law because it provides more clarity as to what is the purpose of the law. It is easier to understand the interpretation of substantive and procedural statutes if we study them together. First of all, there are substantive statutes, which define legal rights, duties, obligations, and liabilities. For example, the Bharatiya Nyaya Sanhita, the Indian Contracts Act, and the Transfer of Property Act are all some examples of substantive statutes. Then come the procedural laws, and as the name itself indicates, they provide the procedures for implementing the substantive laws. For example, the Bharatiya Nagarik Suraksha Sanhita provides the procedures for implementing the Bharatiya Nyaya Sanhita. And if a substantive law needs some interpretation, then the courts will first apply the primary rules of interpretation, such as the literal rule, the golden rule, the mischief rule, etc. And the outcome is interpreted either strictly or beneficially depending on the nature of the statute. Is it a penal statute, is it a welfare statute, or any other type? The rule of casus omissus is also applied here, which means that if something has been omitted or is missing from a statute, then the court should not try to fill that gap through its own interpretation. The court should interpret the law as is. Procedural law is always subservient or secondary to the substantive law, which means that the procedural law cannot supersede or override the substantive law. For example, the Bharatiya Nagarik Suraksha Sanhita cannot take away anything that the Bharatiya Nyaya Sanhita has mandated, or it cannot add something that the Bharatiya Nyaya Sanhita has prohibited. Procedural statutes are generally interpreted liberally because their purpose is to enable the implementation of the substantive law and not become a roadblock. The Supreme Court has also noted that a substantive right accrued to the litigant should not be defeated by citing a procedural defect that is capable of being cured, which means that minor procedural irregularities can be overlooked if they don't affect the substantive rights or the merits of the case. And in general, procedural laws apply prospectively because a law should not create a new procedure and expect that procedure to have been followed in the past from before the enactment of the statute. And as usual, any interpretation of any statute must be validated against the presumptions as to interpretation of statutes.